Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and it shall be heard.
Good morning, please be seated. The first case for oral argument this morning is 76 People versus Shannon Jones.
Good morning, may it please the court.
Can I just ask?
This is a co-counsel.
Welcome. Go ahead.
Good morning, may it please the court. Scott Porter, counsel for Hiscock Legal Aid Society on behalf of Shannon Jones. The template of how this court should decide my client's case is based on his co-defendants, Del Brian Grosvenor's case, which a panel decided in 2022. And Justice Smith, you were on that case. You're one of the 5. And the reason why Grosvenor is important is because of the rationale that the panel used in affirming his conviction, which is that the proximity of the heroin, narcotics processing and packaging material was near Mr. Grosvenor's personal documents, personal property, and that was sufficient to establish both Mr. Grosvenor's knowledge and possession of the heroin that was in the backyard. What is unusual about this case is that the heroin is not found in the house, but outside the house, and so it's the items in the house that is used to tie it to the heroin in the backyard, and because of the processing and packaging material is in plain view in the kitchen, that was the focus of this court's decision. So, my client.
The fingerprint?
Yes, and that's one of the 4. There's 4, I lay out in the brief, four puzzle pieces, and I'm going to go through each one briefly. First, we have, well, let me back up just a little bit. I submit that the focus of this court's panel, on the evidence is the kitchen area. If the focus is on the house as a whole, then the analysis is different. So when I go through these 4 pieces,
All defendants were found in the kitchen area, though, right? Your client?
No, Your Honor. In fact, my client was arrested at a Burger King drive-thru.
I read Grosvenor again this morning. I figured that out. Sorry about that.
None of the defendants were
Right.
in the house at the time. In fact, Mr. Grosvenor was with another co-defendant, Mr. King. But
You understand, but let's,
yes,
he did have personal property in the house. His fingerprints were found outside in the
Yes.
packaging of the heroin that was picked up, correct?
yes.
Okay.
And we have his admission that it was our crib. The 2 pieces of evidence you just referenced to, Justice Smith, the first being the personal document. It was a legal correspondence. That was found in the rear bedroom of the first floor. And let's compare the bedroom to the kitchen. What else was in the bedroom? Well, there were glassine envelopes and 2 grocery bags, not in plain view. If you look to the transcript, the officer who testified about recovering those glassine envelopes testified that he could not see what was inside those 2 bags. That's it, pages 996, 997 of the trial transcript. There were also 2 cell phones and more glassine envelopes and a closed drawer in that bedroom. And that's it. You compare that to what's in the kitchen, and there's a vast disparity in terms of processing and packaging, and also not in plain view. That's the legal correspondence. As it relates to the fingerprint, like the heroin, is found outside the house, and they're close to each other. And there's 2 potential inferences one can draw from the fingerprint. The first has to do with, well, somehow my client touching the shoebox is probative that he knowingly possessed and that heroin. Yeah, but we don't know when he touched the shoebox. We know from the people's fingerprint witness testified that prints can last a long time. We don't know where the shoebox came from. The second part is that, well, the shoebox must have been put outside next to the heroin at the same time. We know my client didn't do that because he was seen 1 minute in the house 2 hours before the raid, and Albert King was seen in the house for 5 minutes shortly before the raid. Those items were dry, the conditions were wet, and my client did not place the shoebox there. To reiterate, we don't know where the box came from. We don't know when my client touched the shoebox. And there's the inference that my client knowingly possessed the heroin because his fingerprint is on that shoebox.
Right, and the jury heard all this, correct?
It did. So I submit that when compared to Grosvenor, the proof just isn't there as it relates to constructive possession. And to move to the second point, this is a close call. And I think in a close call case, the importance of having a fair trial becomes more important because it doesn't take as much inflammatory or prejudicial evidence to convict a client in my to convict a defendant in my client's situation.
Mr. Porter, what would you say is the most prejudicial and preserved evidentiary issue?
Well, of course, I was going to tell you the unpreserved part, but I'll tell you the preserved part. And this is a good example of what I'm talking about. And I thought trial counsel articulated this better than I ever could. The people were able to introduce that my client was the target of this investigation, subject to a high-risk warrant involving the SWAT team. Now, on the surface, it's not as prejudicial as saying that my client was involved in drug activity, which is not preserved. But defense counsel argued that when the jury hears things like high-risk search warrants, defendant as target, the SWAT team, the jury is going to focus on buzzwords instead of the facts. And all defense counsel wanted the court to do was to charge the jury.
Let's break that down a little, Mr.
Yeah.
Porter. And I know you want to do the totality, and I don't blame you. That makes the most sense from your perspective. But are you saying that the reference to the SWAT team is the most inflammatory in that element of the issues that you've got there? Or can you rank them for me? And I know perhaps you don't want to be pinned down, but just for my benefit in writing my notes, is there a way that you would rank the inflammatory nature of that testimony on that subject matter?
Well, my wife always tells me I'm a ranker, and I will rank. I think the SWAT team is the worst, because the
So that
prosecutor...
should never be allowed?
No, I'm not going to say that. I am going to say that limits can be put on something like the SWAT team. And until this case, I didn't know that SWAT teams were involved in executing search warrants. And as a juror, that would definitely catch my attention. And so when the prosecutor says 9 times in her opening, referencing the SWAT team, and then elicits testimony that SWAT teams are not always deployed, and then the SWAT team witnesses testified that they conducted or they executed a high-risk search warrant to take down, and I'm using take down my appellant, my client, that puts him into an elevated category of defendant that as a juror, I want him off the streets. I know the evidence is fuzzy as it relates to possession, and I'm saying this from the standpoint of a juror, but high-risk search warrant, SWAT team, busting
Okay,
windows,
we'll look at that. We'll look at
he
that.
deserves to be convicted. And I just want to put that in context. Thank you.
Thank you.
Morning, Your Honors. Brad Osler for the people.
Why don't you start with the last argument? It's a close call.
With respect to the like high-risk language, I don't know if I would entirely concede that it's a close call.
So unnecessary, Mr. Osler.
Which aspect?
Well, I mean, 9 times on the SWAT team, as Mr. Porter describes, a high risk, I mean, you're there, you got a warrant, you're already ahead of the game, right, is what you would, so that's why I say unnecessary.
I suppose, let me put it this way. I understand your concern, Justice. I don't know if I would share the same concern, only because, and maybe this is something that if you work in law enforcement, you get used to it, I suppose, but like the idea of a takedown car, I mean, that's just that's the terminology, it's what they do. I think the somewhat innocuous circumstances of his arrest, being found, just alone in a car at a fast food restaurant, it sort of minimizes any concern I think that the jury would have that there was he was a dangerous individual, and that's why they needed a takedown car or a SWAT team to execute the warrant. I don't feel that those types of references in this context are particularly prejudicial, and I say that in part too because the overall circumstances of the execution when the police made entry. I mean, there was no testimony about weapons or some sort of extant danger that they encountered when they entered the house.
And how do you, just for my part, how do you distinguish Grosvenor or analogize to it, compare it to the other argument on sufficiency?
So my view on it, I suppose unsurprisingly, is less on necessarily the location of the defendant's legal correspondence in the one particular bedroom, and more about the fact that I think it took about 2 pages in our brief to lay out everything the police found in the house. This was not a minor sale operation. This wasn't possession of a small bundle or a single bag of narcotics or something like that. This was an operation that involved multiple people. There was obviously extensive processing going on, at least in the kitchen, if not elsewhere in the house. It's the kind of thing that I suppose if a person were blind and deaf and lived in the house, you could maybe be excused for not knowing there was a drug sale or drug sales operation going on. But
and it's not just his court paperwork here, if I understand it correctly, the recorded telephone call with the purported girlfriend, the defendant referred to the place as our crib, our little secret crib, or something to that effect.
Correct, and he names, I think, all of the co-defendants by at least by their nicknames in the call. I don't want to rely entirely on his phone call, but I think that's important corroborating evidence, certainly. So I think in light of, and obviously in terms of the totality, I think that favors the people, but that's the angle that I look at this from. I think that's it, unless there's any other questions.
Thank you.
Thank you.
81, People versus Kodka.
Skip 80.
Pardon? Oh, I'm sorry. I skipped 80. I'm sorry. Just a moment. I didn't mean to. People versus Williams. Sorry. Are you a little confused?
Still.
I think I was the one that was a little confused. Okay.
Good morning, Your Honors. Clea Weiss for Andre Williams. I think this is one of these rare cases where this court should exercise its interest of justice jurisdiction. I believe it's merited in this case because careful attention to pleas that involve furlough offers is necessary for defendants like...
The court went through that, and I thought extraordinarily thorough detail, I have to tell you, in terms of describing that, hey, you're not taking this plea just because of the furlough, correct? When you say exercise our discretion, are you talking about the sentence or some other issue? Forgive me for playing catch-up here.
I think that the interest of justice jurisdiction to vacate the plea is necessary, and if I want to rank my factors, I have one incredibly important factor that I would submit to Your Honor. The key fact here is that the plea offer made by the people is to attempted criminal possession of a weapon in second degree. And the plea that he actually pleads guilty to is not the attempt, it's the full charge, criminal possession of a weapon in the second degree. So yes, was he going to accept the offer to attempted? He was, and he says so. But the furlough offer, what is he actually pleading to? the full charge, and that was induced solely by the furlough offer made by the court. And I think that that's shown on page 6 of the plea colloquy, where the court says, and the court is trying to follow the Court of Appeals guidance in Brown, trying to make that record to show that this was a voluntary plea. And the court says, you can say to me without question that you're pleading guilty to this charge because of the deal for 5 + 5. That's the attempted deal. Not because you got the furlough. Is that correct? But he's pleading to criminal possession of a weapon in the 2nd degree, the full charge, because of the furlough offer and only because of the furlough offer. And to me, that's where we sort of fall into interest of justice, because this is a special deal crafted entirely by the court in this case. People did not make this furlough offer. It's the court's offer. You plead to the full charge. If you make it and you don't have any problems, you can withdraw that plea to the full charge and then enter a plea to attempted at sentencing. That's a unique setup. It's a unique setup that the court came up with. And when you're dangling a furlough in front of somebody who's desperate for liberty for a little bit to take care of their daughter whose mother has just died, we're at the height of pandemic uncertainty. That's a situation where Mr. Williams he's not a fair participant in plea bargaining. I would liken it to payday loans. You're desperate to get some money and not get evicted from your home and pay your rent, so you accept a loan with a usurious rate. You're not in a good bargaining position. Mr. Williams, desperate defendants who want that furlough.
Ms. Weiss, respectfully, the facts were not, exactly favorable to your client, and the court went through them right on the record. Your fingerprint is on the weapon. And your client, during the colloquy, as I said, basically agreed with the court's description that there was overwhelming evidence of the possession charge, not the attempt. That's sort of the precursor, isn't it, to everything else that you just described? I mean, isn't that pretty important? And you say that he's in a vulnerable position. The court's outlined the facts before it even goes through the furlough.
I think that there is a factual basis for the plea that's entered, but the plea that's entered, which is to criminal possession of a weapon in the 2nd degree, is induced solely by the furlough offer.
We'll look at that.
Thank you, Your Honor. And there's one other thing that I think that goes into that, which is that not only was it involuntary for the reasons I've been discussing, this is also an unknowing plea, and that's because the court is repeatedly referring to the 5 + 5 as the minimum sentence. That is a mistake. It is not the minimum sentence. The minimum sentence was 3. So Mr. Williams is again entering this plea thinking he's getting a great deal. He's getting the minimum. He's not getting the minimum. That was a mistake, and you need to know what you're pleading to and what the sentencing options that you're pleading to in order to make that decision. So we've got both involuntariness and we've got unknowingness.
That's a fact plain on the record that could have been preserved, correct, through a motion?
It could, and I'll move to addressing sentencing. And at sentencing, Mr. Williams' attorney basically pursues the strategy of throwing Mr. Williams on the mercy of the court and asking not for the enhanced sentence. I acknowledge there's not a motion to withdraw the plea here, but the same reasons that lead to the violation of the enhancement warnings, which are Mr. Williams taking care of his family in pretty extreme circumstances. The child's mother died 2 weeks before Mr. Williams was arrested. He's got some issues going on with his other kids. If there's ever an honorable reason not to show up for court, taking care of your children in such extreme circumstances, I think, falls into that. And whether it's honorable or not, he does fail to show, but I think that a doubling of the people's promised sentence, 5 years incarceration, is an excessive enhancement, given the circumstances of this case. If the people felt that 5 years was an appropriate sentence for Mr. Williams based on the offense conduct, I think that still stands, and I think that doubling simply based on his failure to show up was excessive.
For 6 months.
And it is true, but as the court acknowledges, he did turn himself in after 6 months. So I would ask for a sentence modification from this court, either to the original plea offer or the more moderately enhanced sentence of 7 years, which defense counsel asked for at sentencing. Thank you.
Good morning. May it please the court, Meredith Smith for the people. First of all, the primary issue discussed here is clearly unpreserved. If we're going to go to the merits, I think this was certainly knowing and voluntary. In fact, from the record, I think it could be deduced that it was defense counsel's idea. Lengthy discussion between the court and the defendant. Defendant said he had discussed it with his own lawyer. He knew what was going on. If there was some confusion about the judge calling it a minimum, mandatory minimum, defendant could have corrected the court, the counsel could have corrected the court. I think that's de minimis, it doesn't matter. Defendant knew what he was agreeing to, counsel knew, everybody knew. It's very clear on the record. So for that reason, we believe this should be affirmed.
Thank you.
Thank you.
Now, number 81, People versus Cadca.
Good morning. May it please the court, I'm Tanya Plank for Don Kodka. Unless there are any questions, I'll just rest on my brief.
Thank you.
Thanks.
82, Rivera Ortiz versus Cook. Good.
Thank you, Your Honor. May it please the court, John Mancuso for the appellant. In violation of well-established principles of construction, Supreme Court in this case incorrectly determined that
Mr.
plaintiffs...
Mancuso, would you look at the court's decision? I mean, this is the thing that kind of stood out to me, perhaps, and I'm not sure it's going to make either side happy, but it looks to me when the court sets forth in its own decision that it finds the agreement ambiguous and that there is conflicting provisions in it, typically that cries out for a trial. Just that language alone. Do you agree?
Yes, Your Honor. That is our alternative argument that we did brief. I think the law is very clear that if a court determines a instrument to be ambiguous, which it explicitly stated in its decision, then it cannot be resolved on a motion for summary judgment. You need to have a trial. I mean, the issue here is that the court inferred intent not from the written words of the instrument, but from outside evidence, and there is conflicting proof in the record in that regard.
Both sides moved for summary judgment. Both sides purported that it was unambiguous in their favor, but when the court sets forth, hey, it's ambiguous and there's conflicting provisions, you would have expected the alternative argument to have been adopted.
Yes, Your Honor. That's precisely the case.
Okay, I think we have your argument.
Okay, thank you.
Thank you.
Your Honor, Mark Costello, Boylan Code, on behalf
Wouldn't you agree with that? I mean,
Absolutely not. I mean, you have to look at the decision. The court said...
Yeah.
Well, the court's decision says, I've looked at the operative clauses of the agreement, and they're ambiguous, so I need to look at the whereas clauses. When I look at the recitals of the whereas clauses, the ambiguity is resolved. That's a quote from the court. So he says the decision, the agreement is not ambiguous. What we're dealing with here is a...
Whose job is it to resolve the ambiguity when the intent question is clearly presented on the record?
The ambiguity is, the court said the ambiguity was resolved, so there was no ambiguity in the agreement when the court reviewed the whole agreement. The court's job is to determine the legal issue, and when you're reviewing a conveyance of real property, it's the court's job to interpret that legal document as a matter of law.
In every case?
Well, and certainly in this case, and we're dealing with real property law 240 subsection 3 that says to determine the intent of the parties, you look at the whole agreement. The court looked at the whole agreement. I don't know that the court's decision could be any clearer when he says the ambiguity is resolved, because I've looked at the whole agreement. The problem with the agreement is it talks about trees. You look at the first paragraph of the operative clauses. The first paragraph of the operative clauses talks about trees, but when it refers to the trees, it says the aforementioned trees. So the trees has no context unless you refer back to the whereas clauses, the operative clauses of the agreement. And that's how the court resolved the ambiguity. It doesn't know what trees they're talking about, doesn't know what obligations they're talking about regarding these trees. The whereas clauses of the agreement establish what the trees are, discusses the trees, the blue spruce trees. It appends a map stating where everything's located.
Mr. Costello, I mean, it seems to me that in front of a fact finder, you're in a position to make a pretty common sense argument that says, wait a second, why would we agree to maintain and replace as necessary these trees if we couldn't see them, for crying out loud? The other side's going to want to tell the fact finder, wait a second, that agreement clearly says that we're not giving up any other rights. And also, they're going to argue that, hey, wait a second, Judge, we didn't give them the right to view. Seems to me that this all needs to be kind of worked out in front of a fact finder back and forth to try to convince the fact finder what was really meant by these parties and when they made this agreement.
This is an equitable lawsuit, Judge, and the fact finder is the judge.
Okay, we'll look at that. Thank you. 83, Rag Herkimer LLC versus the Glider Oil Company, Inc.
May it please the court, J.P. Wright, Von Schenecke King, on behalf of the appellant, the Glider Oil Company, Inc. The judgment below should be vacated and reversed for multiple reasons, some of which we argued before this court in May of last year. And those arguments dealt with the trial court's decision in order to preclude Glider Oil from asserting its liability defense at trial. Now, as the court is aware, after that oral argument, but before the court issued its decision, the trial court went ahead and entered final judgment that mooted the prior appeal. So Glider Oil had to file another notice of appeal, posted a bond to stay the judgment, and here we are. The first reason for reversal, as I argued before this court in May, is that RAG's motion was an untimely motion for summary
All
judgment.
that gets you is a new trial.
Correct,
You've appealed from the judgment.
correct. And the judgment brings up all the prior intermediate
And what's your
orders.
most effective argument, do you think, in appealing from the judgment?
That the pretrial decision by
That's your most
the
effective.
judge.
So all you really want from us is a new trial?
That's our initial argument, Judge. If for some reason the court is inclined to grant our cross motion, which was asserted below, and preclude RAG from arguing the lease construction that it favors, we'll take that, Judge. But yes, we're here looking for a reversal and a new trial.
That's all you're looking for?
No, he just said if he could get something else, he'd take it.
If the court is inclined to grant our cross
I
motion,
heard it right, presiding Justice Smith. I just wanted to make sure I got it right.
if the court is so inclined to grant our cross motion, Judge, we would certainly take that and appreciate it.
Well, did the plaintiff in this case have an opportunity to effectively challenge the argument as to whether it was old contamination or new contamination? Because it seems like that issue was taken out. And your argument is that it shouldn't have been taken out because it was untimely. But if it's back in, if we were to reverse on the timeliness issue, wouldn't you agree the plaintiff should have an opportunity to challenge whether the contamination was old in the first place or whether it was new contamination from 1993, 1994? Because I know there was testing in 93 that showed it was clean. 94 is when it cropped up again.
Yes, so certainly, Judge, and I think that's what the trial would be. I mean, we're going into this 5 days before trial, this decision comes out, takes the liability issue away from the jury. We were going to put our expert on and say, no, this is old contamination. It's from the Johnson Products gas station that was there in the 70s and 80s. And plaintiff then would, I can't say what argument they're going to make, but they would have to present their case in chief as to why there's liability. They could rely on the lease language, which is what they did before the trial court, but then they can have their own expert come in and say, no, based on the age of the contamination, et cetera, this was recent. I can't, give plaintiff's counsel advice on what to do. Thank you, Judge, appreciate it.
Mike Longstreet on behalf of R.A.G. Herkimer. To get to your question, the lease, this is a little odd situation because they agreed that they were the owner under the regulations, which is basically the navigation law. The owner under the terms of the navigation law is liable, period, regardless. And the only way they get out of it is if they prove that we were the parties, R.A.G. Herkimer, that spilled it, and we didn't. So what I'm saying is there's harmless error. They were liable under the terms of the lease. They were liable under the terms of the navigation law for this. The lease itself demonstrates that they intended to be liable. They took the property as is. They said they completed a complete inspection. They did in fact do a complete inspection. They took all the tanks out. They saw what was there. And almost 30 years later, they come back to court and say, wasn't our oil. Well, they're the ones that did the cleanup. They never said that at the time. At the time, they were designated as the responsible party by the DEC. When you're designated as the responsible party by the DEC, you're the one who cleans it up. And the reason for this motion, and they argue, well, you shouldn't have made the motion. They joined in this motion, and the reason was obvious. Because if we didn't have this decision, we were going to go through 2 weeks of boxes and boxes and boxes of DEC documents proving that, in fact, they knew they were the owner and they were working with the DEC trying to clean it up. It's just they didn't do very much, and they really didn't follow the DEC's instructions, which is why the motion was made, and they can't say with a straight face that it wasn't necessary, because it was necessary.
Mr. Longstreet, take me to the issue pertaining to the appeal from the judgment after trial with respect to who paid for the remediation.
Right. Yeah, my client, R.A.G. Herkimer, is the owner. They have an operating company that is their managing agent. Their managing agent made all the payments.
Is that Ambient? Was that Ambient or Gibraltar?
Ambient is the expert who did the analysis and did the cleanup. The managing agent is Gibraltar. They're they're not one and the same. They are separate entities with separate ownership.
You didn't prove that they were one and the same at trial.
We proved that they were.
I'm sorry. You didn't prove at trial that they were one and the same, that they were an alter ego for another. As you just said, they're separate entities, correct? They're separate persons under the law.
You have an ownership entity, and then you have the managing agent, which is the operating company that pays for everything.
But they're separate persons under the law, right?
I didn't hear you.
I'm sorry, not being loud enough. I'm suffering from going to the Bills game yesterday. They're separate persons under the law. Gibraltar is one, and your client is another. Gibraltar paid the money, that person paid the money, and is not a party to the case. So how is it that another person, your client, can make any claim whatsoever to the cost of recovery when that person did not pay?
Because, and I cited in my brief, when you are the managing agent and you pay on behalf of someone, you are entitled to make that claim. And there was an explanation of how they made reimbursements through the various corporate entities for that. That's the way business is done in real estate these days. Okay. Operating companies don't operate, or non-operating companies don't operate. That's all I have, Judge Smith. Thank you very much.
Thank you.
Nice to see you, Judge.
84, James Lime versus RAC Engineering PC.
Good morning. My name is Matthew Lerner, and I represent the town of Clarence. May it please the court. This appeal is about a late notice of claim and also about a late cross motion for leave to serve a late notice of claim that was made outside the 1 year and 90 days of the statute of limitations. I'm going to address briefly 3 points. The first point has to do with just basically the timeline. This was a case that happened when the then Governor Cuomo imposed the tolling. So the collapse of the house happened in September of 2020. Based on the Harding case, this court's Harding case, the accrual started from November 3rd, 2020. And so the deadline would be February 1st, 2021, one, to serve the notice of claim. That was not done. The service of the notice of claim was May 26th, 2021. There was no motion for a late notice of claim at that point. Summons and complaint, April 21st, 2022. Just back up a second. The late notice of claim under this court's precedent is a nullity. At the point of the motion for leave, it's a cross motion. They actually brought the cross motion, and it seems like an afterthought. They cross-moved for late service of a notice of claim, where there's a nullity of the late notice. That was made, should have been made February 1st, 2022.
Did the court have the power or authority to consider that cross motion at the time that it was presented?
Under this court's precedent, Justice Kern, no. And I would rely on the Bennett case, the Fixter case, and the Walt case. Briefly, if the court has any questions regarding my alternative argument that there was a abuse of discretion regarding the patently meritless part of, if you get past the initial late notice of claim issue and there's a looking at whether it's patently meritless, our position, the town of Clarence, is that the claim is patently meritless because of two things. One is James Lime's testimony. He claims that there was groundwater and a pump station that was in a subdivision, and because of the constant pumping of groundwater, it caused the collapse. When he was asked at his 50H hearing where he learned of this theory, he said, well, it's just theories from a neighbor and his brother-in-law.
We understand that.
Okay. And then the last, if you want me to address it, are the factors that are considered when the court is analyzing whether to grant a late notice, late service of a notice of claim. I would just submit that the court on every issue was incorrect. And I'll just briefly address the first factor, and I'll leave it at that. It would have to do with the essential facts. The court looks at whether the municipality had essential facts that constitute the claim. Our first argument is we really don't know what the claim is, because by admission...
I don't think any of the engineers have really determined what the actual cause of this collapse was. Isn't that correct?
Yes, Your Honor.
The plaintiffs and your engineers as well? No one could really say. And again, it's speculation. Mr. Elaine saying, well, a neighbor and a brother told me that this is a possibility. And there's really no actual findings by an engineer indicating that this was the cause.
Correct, Your Honor. And on top of that, Mr. Lime stated at the 50H hearing that his engineers didn't even connect it to the town, and they don't know what was causing the collapse. So I'll just leave it there. Thank you very much.
Thank you.
Thank you.
Good morning, and may it please the court. Thomas Lyons from Duke Holzman here on behalf of the plaintiff respondents, the Limes. For the purposes of today, Your Honors, I'll focus on what I consider to be the most primary salient issue, unless Your Honors have any questions regarding the secondary and tertiary arguments raised by the appellants. The primary issue that I view here is exactly what Justice Curran put his finger on during the initial presentation, which is whether the lower court had...
How do you deal with the case that counsel cited, it's cited in the brief, Bennett? That seems to be directly on point, Counselor, and I noticed in your brief you don't even cite the Bennett or address it.
Correct, Your Honor. We don't cite to it. However, I would direct the court to several decisions and one salient point on Bennett. Bennett itself does not directly address the same situation that we have present in this case. Undisputed on the record before Your Honors is the fact that there was a notice of claim served and an action commenced within the year and 90-day period. What Bennett stands for, absent any other consideration, is simply the principle that a plaintiff who didn't move or within that period couldn't be granted that relief. What the court didn't evaluate in Bennett and what other decisions have placed heavy emphasis on is the purpose of the statute and the presentation of the fact that the town in this case had unequivocal actual notice and opportunity to not only investigate, but actually did investigate in this case. That is why the lower court had the ability to grant the nunc-pro-tunc relief, notwithstanding. For that proposition, Judge, I direct your honors to several decisions. First, and please understand, I'm going to butcher this pronunciation. I think it's Bredge versus Town of Tonawanda. It's this court's decision from 2017. It's 148 AD 3D 1792. I would also direct your honors to two other decisions that were cited in our brief. It's Terragino versus Brockport, 4th Department, 2011, and Matter of Newcomb versus Middle County Central School District Court of Appeals, 2016. For all of those cases, the courts unequivocally talk about and place heavy emphasis on the purpose of the statute is to give the municipalities the opportunity while the evidence is fresh to investigate. That is why when you're dealing with a situation where no notice has been served, where an action has not been commenced, and the relief being asked for has not been moved for in the 1 year and 90 days, a court doesn't have the ability to grant that relief. That's not the circumstance we're dealing with here. We have the action commenced, we have the notice of claim served, and we have actual unequivocal notice and actual investigation by the town.
Doesn't Bennett say that the earlier service of a notice of claim is a nullity?
And, Your Honor, it does in fact say those words, but again, that's where I point to the fact that the Bennett decision doesn't take into account what we have here, the circumstances behind the purpose of the statute and those time limitations. This is...
Are you saying Bennett was wrongly decided?
In that limited point, Judge, where we're dealing with a situation in this case where we have an actual, not just opportunity, but an actual investigation, actual notice, service, and commencement within the time period, it satisfies the underlying purpose and intent of the statute, and that's why those other decisions have held that.
You're saying that Bennett failed to take into account those underlying purposes of the statute, and therefore, under your argument, you're saying it must be wrong.
To that limited point, yes, Your Honor.
Thank you. Do you have anything further?
The last thing I would like to touch on is just simply the last point that counsel had noted with regard to notice of the essential facts. What we've talked about in our brief is notice of the essential facts versus a notice of the legal theory that we might be pursuing. To Justice Montour's point about the legal theories that are in development both by all parties here with their experts. The cases I would point your honors to were both cited in our brief. It's Turner v. Roswell, 4th Department 2023, and Carpenter v. New York Advanced Electric, 4th Department 2010. Pending any further questions, that's all I have, Your Honor.
Thank you very much.
Thank you.
85, Maurice Foster versus Bombardier Recreational Products. Oh, I'm sorry. Justice Kane is recused on this matter, for obvious reasons.
Fill us in a little bit more.
Pardon?
You could fill us in a little more.
Good morning. Could you unmute? There, perfect. Thank you.
All right, are you able to hear and see me?
Yes.
Oh, very good. May it please the court, Martha Donovan on behalf of Appellant Christina Kubacki. It is our position here that the emergency doctrine applies and that under these circumstances, defendant responded reasonably to an emergency situation when plaintiff motorcyclist lost control of his motorcycle, crossed over 8 lanes of traffic, flew over a concrete barrier, and collided with...
That may all be true, but aren't we really dealing here with the running over him after the fact?
Well, that is the allegation. Defendant has not conceded that that is how this accident in fact happened. But for the emergency, when the emergency doctrine applies, the factors that are viewed by the court are whether the driver's awareness of the situation and her actions prior to the occurrence. Here, there's absolutely no reason for defendant to have been aware of this situation or to have anticipated such a highly unlikely occurrence. And as far as her actions prior to this occurrence, they're unquestionably reasonable. She was in her lane of traffic, she was proceeding with the speed limit, and she was looking at the roadway ahead of her. There was really nothing else that could be expected of her as a driver. We've cited in our brief the Vitale, the Weymouth, the Lonergan, and the Mendez cases, which all stand for the proposition that driver is not expected to anticipate or avoid a projectile pedestrian in the roadway. And here, I think the critical factor is that the defendant had already cleared this area of the roadway before this accident occurred. She had no reason to anticipate that an obstruction would appear in the roadway after she had already viewed that it was clear and safely crossed over the area.
Counsel, don't we have an issue of fact with respect to the action taken by your client upon feeling the impact to her vehicle? It seemed that she testified at her deposition that she upon feeling the impact, paused and proceeded slightly forward to reach a safe location, is the way she depicted her actions with her vehicle. The two non-party witnesses referred to her as taking off. Her vehicle started taking off, which to me presents a different visual image on the roadway. As somebody trying to, to get out of the situation for whatever reason. I'm not suggesting she, felt she was at fault or anything, but that the description of how her vehicle moved, very, very different. And why doesn't that in and of itself create an issue of fact?
Well, I don't think it creates a question of fact. Number one, citing the Michael case, the 2017 case from the Fourth Department, where this court held that in response to an unknown mechanical issue, it would have been reasonable for the defendant to pull over to the road. That's exactly what she did here. The second thing is that in an emergency situation, you can't second guess the actions of the driver, even if it turns out that what they did later appears to have been wrong. Let's consider for example, if the plaintiff had been underneath the wheel of her car and she had stopped, and then he was trapped under her vehicle, but she had stopped. Well, then looking back, we would second guess her decision and say, well, why didn't she pull forward? She didn't react reasonably here. I mean, this was highly unlikely what happened. And she did the reasonable thing. She pulled over to investigate the situation. There was no reason for her to think what had happened had happened. He simply wasn't visible.
Counselor, following up on Justice Nowak's point, I think, I'm looking at the charge on the emergency doctrine. It seems to me that one of the issues also is, even assuming an emergency, the person faced with such an emergency must still act as a reasonably prudent person would have. Are you saying that the only reasonably prudent course of action was to keep driving? Or could a jury equally consider that or conclude that it was reasonably prudent for the driver to simply stop? Isn't that an issue of fact?
I don't believe that's an issue of fact, because I think that was a completely reasonable response. And the emergency doctrine doesn't require the finder of fact to second guess the decision.
I think you've made that point. Thank you.
If the court has no further questions, I'll rest on my papers.
Thank you.
Good morning, Your Honors. May it please the court. Jacob Pierkowski for the plaintiff, Maurice Foster, on this matter. I think the issue is quite clear that the emergency doctrine creates a question of fact here. We know distinctively that there's two impacts, and the defendant never puts forth conclusively the idea that there's one impact. Now, if there was one impact, if this defendant was truly driving through, was struck by my client's motorcycle and happened to run him over, I would agree that there's an emergency doctrine issue, and maybe this defendant was not negligent. In this situation, there's two eyewitnesses, one motorcycle rider behind the plaintiff, one in front, who both witnessed the defendant at a stop position at the first point of impact. The defendant herself testifies that she was stopped, took a moment to reflect, and then pulled over. That's exactly what the PJI contemplates in 277. That's exactly what the emergency doctrine is getting at. The fact is, and to amplify this, at best, she may have looked in her rearview mirror. There's a 200-pound man wearing a white motorcycle jacket with a white helmet, white boots, white gloves, riding a white three-wheeled motorcycle, which would not have tipped over upon impact, and no witness says that it does, sitting next to her vehicle, and she fails to notice it. Instead, what she does is she pulls forward.
No negligence arose on behalf of the Kabaki defendant until after your client's motorcycle struck Kabaki's vehicle, correct?
That's right. I don't have any evidence that she had done anything negligent until she pulled forward. And just the simple idea that you feel this impact that's so strong that it jolts your body inside of your own vehicle, that a motorist who's roughly 70 feet away at the other side of the intersection hears it, hears the impact, comes over to render assistance to Mr. Foster as he lays on the ground, and the most you do is maybe look in your rearview mirror.
Okay, I think we have that.
That's my point, Your Honors. I think there are real questions of fact here, and I don't think the emergency doctrine applies.
Thank you.
If there are no other questions, thank you.
86, Rose versus Anthony Ellis in City of Utica.
Good day, Your Honors. I'd like to start with Brown versus New York State, 980 3rd 23, which says that when the federal court does not reach the pendent state court claims and either remands them or just doesn't reach them for whatever reason, that there is no identity of issues and no full opportunity to decide the case. It was the holding of the third department, and there's a large number of cases in it, and I contend that effectively ends the collateral estoppel issue in the case. Beyond that, Ellis's credibility is abysmal. He claims he was shot at, but every piece of evidence in the entire, objective evidence in the entire case shows very clearly that Mr. Ellis was not shot at. The gun was obviously pointing at my client, as shown by the wound in his abdomen, and which was fatal. And as a result of that, I contend that we're entitled to the falsus in uno charge if and when I ever get this to trial. The next is the question: are there questions of fact on the case? Ellis claims he was shot at. The proof is that he was not shot at and could not have been shot at after the reconstruction was done. The city claims that he doesn't claim he was shot at, they just claim he was sufficiently threatened to have a problem. There is a question of fact as to whether he was suicidal or whether he was removing the gun. What it is with the gun is that he had a strap over his shoulder, and it was over here, and when the officer did that, he went up like this, and right at this point, the gun went off. Now, the question is, this is the handle up here, and the barrel is down there.
I understand that, okay.
Yeah, and it went right through his liver, hit the renal artery, and they couldn't stop the bleeding. So the coroner report says he was shot point blank with a shotgun. But the problem is, does that mean that he's suicidal, or was he removing the gun and his finger got shot right here with the officer's bullet that was shooting at him, and that triggered the gun to go off? There's a huge question of fact on that, and so many more. I'm not even going to try to list it. Everything is contested.
Anything further?
Just further, we have a quick note on Noseworthy. He is, because my client died from the bleeding to the liver wound, and we're unable to determine what his state of mind was, and it was not pointed at the officer or what he was doing or what happened. We believe we're entitled to the Noseworthy charge in the case. And then there is the quick rundown of how this is supposed to be handled under the police rules. Generally, you wait for backup, which was seconds away. French came through the gate, he said, just after the shooting, and then I came up and saw him there. And then we do take with the backup covers the individual with the gun, and then you just get on your megaphone, and while he's covered, you ask him to drop the gun. And if he doesn't, you keep talking to him until he does. And if he does anything dangerous or threatens anybody, then you shoot him, because you can't have it.
I think I
And-
understand that.
Yeah, okay. And the special duty argument fails because it applies only to the failure to protect group of cases and the fire departments. There's no general duty of a city municipality people to everybody in town to to protect everybody and everything perfectly. But it doesn't apply to the cases where there's direct contact between the people, like beating up or shootings. And as for discretion, we contend there's a question of fact all over the place on that. And the duty owed by, and so Ellis did owe a duty to the plaintiff not to inadvertently, not to shoot him the way he just did. What it is it just says he charged into the park, and about 20 feet into the park, shot the jungle gym
We understand
first.
that.
Okay.
Thank you.
Is there anything else, or any questions your honors have on the case?
Thank you.
Okay, thank you.
May it please the court. My name is Zachary Orrin, and I represent the City of Utica and Officer Anthony Ellis. I will attempt to respond to what I believe were 4 points made by appellant's counsel. So the first argument is the collateral estoppel issue.
Counsel, before you get to that,
Yeah.
just quickly, if we have a lot of testimony here. We have a lot of sworn testimony, a lot of non-party witnesses that have been deposed. Could a jury reasonably conclude that the accident happened the way that counsel just described, where you have Mr. Rose attempting to take the gun off his shoulder? As he's doing that, he gets shot in the left hand. That causes the trigger to pull, and that he ends up shooting himself as a result of that. Is that reasonable based on the testimony that we have?
No, and for several reasons for that. First of all, if you look at the medical examiner's testimony, the bullet enters the dorsal side of Mr. Rose's hand, enters palm, and exits pommel side. What happens, and this medical evidence is irrefuted from the affidavit that's in the record, when that bullet enters his hand, it's going to cause the ligaments to make the hand open, not close. Plaintiff never produced any expert with any kind of medical training to create, to put in such admissible proof that this chain of events occurred. It's mere speculation on their behalf. And following that one step further, that only happens if Ellis spins the shotgun around, awkwardly takes it off, breaks every cardinal rule of fire safety handling, and points the muzzle at himself. Then Ellis somehow hits him in the hand and the gun goes off. And specifically, the only source of testimony they have for the strap saying that the firearm was affixed to plaintiff is Lonnie Willis. That's where it is in the record. And specifically, when asked, Lonnie Willis gave no opinion as if there was enough time or not, whether or not the officer gave Mr. Rose enough time to remove the shotgun or not. And at his testimony, he even says he presumed that the gun was strapped to him. He did not say that he actually saw the firearm strapped to him. Finally, too, I would say it doesn't matter if you're trying to drop the gun or not, because Officer Ellis's commands were to show him his hands. You just put your hands up. And Officer Ellis can then tell him what he wants him to do. He might want him to lie on the ground with the shotgun still affixed to him. That could be well within a police discretionary tactic. So in regards to the strap, that's my analysis for the strap. And we've also heard testimony today, or arguments today, about Ellis confusing which end of the firearm was the muzzle and which was the, what was left of the pistol grip. I encourage all of your honors to look in the record at R126. That is a picture of the sawed-off shotgun at issue. As you can see, the barrel was cut off, and the buttstock was completely removed such that all that remained was this little pistol grip. And there are 3 other witnesses in the record, 2 of which have extensive firearms experience in handling firearms, that also got the direction of the muzzle wrong, meaning they too thought it was pointed at Officer Ellis. So with that testimony, under that stress, that was a reasonable mistake of fact that he had. Finally, and most importantly, plaintiff's own firearm expert, this is at R2233, said the gun could have been spin around in less than a second. So even if the direction of the muzzle is not pointing him at the very moment he fired, it's totally irrelevant because he was still absolutely in danger. And I will say that kind of leads to my collateral estoppel point, which I will say, every court that's looked at this, and those courts being the United States District Court for the Northern District of New York, United States Court of Appeals Court for the Second Circuit, and the United States Supreme Court, which denied cert, and last but not least, the United County Supreme Court has found summary judgment for Officer Ellis in this regard. And I'll say the Second Circuit ruled on undisputed facts it was objectively reasonable for Ellis to believe that Rose possessed a threat or serious physical.
We're well
All
aware
right,
of
thank
that.
you. All right, well, your honors have any other questions?
Thank you.
All right, thank you, I'll rest.
Thank you. 88, State of New York versus Tyree A. Good morning to both of you. Mr. Chamberlain?
Good morning, Your Honor. Can you see and hear me okay?
Yes, thank you.
Okay. May it please the court, Patrick Chamberlain from Mental Hygiene Legal Service on behalf of the appellant Tyree A. In this case, we are asking the court to reconsider some prior appellate rulings that have held that the legality of an offender's incarceration, frankly, is irrelevant or does not matter at the time an Article 10 petition is filed under the mental hygiene law. Factually, there doesn't appear to be any dispute
Just a
here.
minute,
Yeah,
Mr. Chamberlain.
Chamberlain, can you hear me okay?
I can.
Okay, my question is, aren't we supposed to presume that the legislature was familiar with the statutes in existence at the time when they adopted this new statute that you rely upon, and therefore, because they didn't alter the language of mental hygiene laws, Article 10, with respect to what Joseph II, in our case, decided, we should presume that they meant no change, shouldn't we?
I certainly think that's a factor the court can consider. I don't think that necessarily is determinative of the issue. I mean, it's certainly within the realm of possibility that the legislature was focused on these sentence reductions and this crediting of good time on parole and failed to acknowledge or recognize the fact that it would have downstream impacts on some other statutes, including Article 10. So certainly that's a factor, but I don't think it's determinative because it's very conceivable they may have just simply overlooked that reality. I just think, our position at this point is that the legislature has made clear that it's taken a fairly dramatic change in terms of how it's approaching criminal justice policy in the state. This is one example of it, this Less is More Act, talking about the legislature's focus on reducing the number of people being supervised, reducing the numbers of people who are incarcerated, getting people reintegrated into society more promptly.
Mr. Chamberlain, it's me again. I'm sorry to interrupt you again, but following up on that point, I mean, in the state's brief, they make the statement that in your brief, you do not explain why the improper recalculation of the sentence under the Less is More Act is any different than the sentencing calculation error identified in matter. That seems to be true. I don't see that you give us a reason as to why that changed the law, other than you want us to use the legislature's policy to reinterpret the law. Have you given us any reason based on the phraseology of the law to change what we did in matter?
I will concede that the matter case does say that a miscalculation in a sentence in docs does not preclude an Article 10 petition from being filed. The Less is More Act did not explicitly change that fact. Our position is simply that these cases need to be reconsidered in light of the clear policy changes in
That's
the
what we're going to have to
legislature.
look at, and that's what we're going to have to look at very carefully. Anything
Understood.
further,
And
Mr. Chamberlain?
just briefly, Your Honor, I just think it's important to emphasize that when we're talking about somebody, indefinitely losing their liberty for a period that extends beyond their criminal sentence, frankly, it seems fundamentally unfair that errors by docs should be brushed off as irrelevant, and that they should be able to sort of double down on the violation of this person's liberty interests simply because of this case when the legislature has clearly indicated a policy interest in preventing that from happening. Thank you.
Thank you. Mr. Brady?
Yes, Your Honor. Just very briefly, the law is well settled that the lawfulness of an Article 10 respondent's custody is...
Mr. Brady, Mr.
Yes.
Brady, it's me again, but in Joseph 2, I forget, but I know Judge Saperic wrote the dissent there. I think there was a 4-3 decision. So, and then we've got our matter case that follows Joseph 2. Isn't the point of this appeal seemingly that they want to get to the Court of Appeals to try to indicate that the court should interpret the statute according to the policy of the new statute as opposed to the language? Is that what we have here, and should we do that?
Well, I'm not sure what the motivation for the appeal
That wasn't
is.
fair. That's a good point.
That is a good point.
What I'm driving at is, I see this as a policy argument for us to reinterpret our matter case, if not abrogate, and to more follow the dissent that Judge Saperic wrote in Joseph 2. And maybe that's a legitimate perspective that we should take in terms of taking the statute and interpreting it according to the more recent legislative policies.
Well,
so is that what we should be doing?
Well, no, and I think Judge, the dissent that you're referring to is it really hasn't been. There was I guess a fear raised in that dissent that somehow the state would use Article 10 in some kind of nefarious way. I think in the brief they say the state was somehow unfairly rewarded. Article 10 is not the criminal law. Article 10 may or may not result in civil confinement, and it's a mental health law.
We're aware of that.
but I think like this case, this would certainly be a poor case to test that, since here the miscalculation. I think it's maybe a 3-week miscalculation. The law changed on March 1st, 2022, which credited people who were on parole. We gave them an extra 30 days if they were successful, each 30-day success. Not everybody was recalculated in a timely fashion. There's nothing nefarious about this. After the Article 10 petition was filed, that is only when people realized that he might have been entitled to be out earlier.
Mr. Brady, on that point, and I noticed you just went for he might have been entitled to.
I'm sorry, he was. I'm conceding that.
Okay, thank you. That's what I just my notes.
I'm sorry. He should have been out on July 13th. The petition was filed on August 8th, but it wasn't until sometime after that, after his counsel inquired of the state about a recalculation, that it was determined that he should have been out earlier. But that's really no different from any other sentence miscalculation. If there was some kind of bad faith that could be shown, I think that might be problematic, and that might feed into Judge Shaparik's.
I think we have that argument. Anything further?
Okay. I have nothing to add. I'll rest on my brief.
Thank you. Number 89, Rosario. Pardon? Rosario Barone III versus Liberty Cab Company. Mr. Brady, you're still here. Okay, thank you. Now Mr. Vincent is here.
All set. May it please the court, Sam Capizzi on behalf of the plaintiff. I'd like to start with proximate cause. And the court below erred for a number of reasons, but I think permeating the entire decision is this idea that there's an intervening and superseding cause of Rosario Barone getting shot. And I think we have to go back to the record, particularly pages 150 through 160, and even more narrow at page 152. Mr. Barone sets forth what was going on in that cab at that time. This isn't an unknown assailant case. This isn't some spatially distant injury from the negligence. What's happening in this cab is that he got shot because the door didn't open. Now, it's not just an argument. That's from the 3 people who were in that cab that night. Rosario Barone describes it during those those pages that I've cited, and he's telling, I mean, this is a 23-year-old who's on the job as a cab driver, very short time, and he has the wherewithal to talk the shooter, Mr. Williams, out of shooting him. Look, I've got no money. And at one point, the testimony from Mr. Barone is that Williams throws the wallets on the floor and wants to get out. And then the next thing Mr. Barone describes is he can't get out. He can't get out. Now, we know that that door wasn't working because just a few minutes before this happened, Mr. Williams asked Mr. Barone to go back to his house. And remember, the door wouldn't open. The testimony is very clear. And what actually happened is Mr. Barone reached out because the outside was working and let him out. So at the very moment where the gun is at Mr. Barone's head, there's a discussion going on, go have your night. I don't have any money. The risk diminished significantly. And then what happens is he can't get out. Mr. Barone perceives that as Williams thinking, oh, he's trapping me. Oh, he's trying.
Okay, we've got it.
Okay.
So, let me interrupt you, sir, just so, because I want to focus on the specific fact that seems to be unique to this case. And you started this way, I just wrote it down a second ago, that your client got shot because the door didn't open.
Yes.
So what I want to see is whether or not we can appropriately sort of take out of that, yeah, the partition would have been nice and a camera would have been nice, but what's the really motivating cause here, to use a poor phrase, is that the fact that the door didn't open. See, when I go down the partition path or the camera path, I start looking at it as potentially as legislating that all cabs must have this. And partitions, can or cannot be useful. Cameras maybe could, maybe not. But that means if we're going to require it here, we require it in every case. And I don't see that as our role necessarily, but so you can talk about that if you want, whether or not that's our role in this case, or should we focus on the unique characteristic, as I see it about your case, is the door that malfunctioned. So those are two different issues. Should we focus on the door, and do we go down the legislative path, as I see it?
The latter, the focus on the door, I guess, in the question. The partitions and the cameras, I mean, there's no doubt the city of Buffalo recommended them, and they decided not to do so. But I think what I'm focusing on in this proximate cause argument, because I think that's what the court focused on in saying that all defendants here had no liability, is the fact that the door didn't open. That's what I'm focusing on. There was no, as I look at it, intervening or superseding cause. This event was unique, very unique.
So you're saying that it's foreseeable that because the door latch wasn't working properly, that it's foreseeable that this incident would have occurred and the driver would have been shot?
I am, and because foreseeability is what we need to talk about, I think, to support why I say that. And this is a very violent and crime-filled occupation. It is. OSHA said so several times. Mr. Yunke, who owned Liberty Cab, said so a number of times in the press. I've listed 15 before this accident happened.
What notice did Buffalo management have that this lock wasn't working?
Well, a couple of things. First, there isn't any.
They don't have actual notice, do they?
There wouldn't be any actual notice because they never looked. And that's my point. Is that there's no.
To their attention either. Wasn't the requirement, I think, that the drivers, if they noticed that there was a mechanical defect, they had to report it, and then it would be put out of service?
My recollection of the record is the opposite, and that is that it's no requirement. The fact that drivers would usually, often, could. There was no mandate.
Practice, maybe not a requirement, but
there's no mandate. There's no manual. There's nothing.
Okay, we've got that.
So my point is that it is foreseeable because of the industry, because of Mr. Yunke's own statement and statements plural. It is foreseeable that crime could occur. There are a number of instances where drivers were shot.
More conceivable or foreseeable?
I would say foreseeable. A number of instances where it happened.
Just to focus on a concern of mine, the court found persuasive the Santiago case, as I recall. and tracing the San Diego case down back into, as you would expect me to do in the PJI, that really shows up in the intervening cause section vis-a-vis the concept of when an act serves as the condition or occasion for the subsequent act. So that's really what I'm focusing on here is, isn't this really a situation where the malfunctioning door merely furnished the occasion or condition for the robbery and was not a proximate cause of it because the robbery was an intervening cause that was in and of itself?
I think not, because it flows from the very act. There's two cases that I've cited, actually were cited to you, and we all wrote about them. One is the Dyer case out of this department. That's an unknown ATM robbery, unknown assailant. And then the Rodriguez case, which is a roof damage case. But those were instances where this court wrote about, well, this is just furnishing the circumstances. And the idea is that the harm didn't flow directly from the negligence. But here, the harm is only coming about because he can't get out of the cab.
We'll look at that.
The only thing I want to mention, Your Honors, is duty. The decision by the lower court just talked about duty in one aspect, and I'll just limit it to that. And the court held that Liberty owed no duty to maintain the cab because it wasn't an owner. Well, that's contrary to the cases that I've cited as Liberty being a lessor. Remember, renting the cab. They've created this way of doing business, and there's nothing nefarious about it. They can do business that way, but that causes duties to arise. They're leasing this cab to Barone. They have to lease this in a safe manner. And to your point, Judge Montour, they have to do inspections. There's no record of any inspection, just could be, would be, and I just don't even think they first supported their motion for summary judgment. And if anything, they've just created a question of fact. I think there's questions of fact all over this record. Last thing I'll end with is, and the final thing that the court did below was it determined what I consider to be valid questions of fact on a couple of things. Notice is one. The other is whether there was even the existence of a dangerous condition. Well, that's for the jury. There's 3 people in that cab who all testified that the door wasn't working. Unless there's any other questions, that's where I'll end.
Thank you.
Thank you.
Mr. Vincent?
Your Honors, counsel may please the court. For the Liberty defendants, I would just submit that Justice Furlong got it right, and we essentially say that in our submission. Unless the court has any questions, I would rest upon the submission and the judge's decision.
Thank you. Mr. Morris?
May it please the court. I'm James Morris. I represent the Buffalo management and the owner's side in this. I'd like to start off with the facts a bit. There's a suggestion here that there's a defect. In most cases that I've handled over the years and seen over the years, if there's a defect, there's some expert talking about exactly what the defect is. Here, there's a suggestion that since the door didn't open, that it was defective. There are other possible explanations. I mean, is child safety locks on doors such as this?
Well, when you move on proximate cause, Mr. Morris, the way I look at it anyways, is that we're already past question 1 on the verdict sheet. You've already been found to be negligent. So when you move on proximate cause, it sort of is almost an assuming arguendo if we were negligent. So that's, when Mr. Capizzi started proximate cause, maybe that's not where you want to start. You're starting maybe with something else, but that's how I have it organized in my head.
I understand, Your Honor, but very briefly, the lack of proof of the defect. Vehicles put in drive, the door is locked on the inside. There's child safety locks. There's no proof here of a defect. There were inspections following the event by the Buffalo Police. They're described in Mr. Darka's testimony. There were also inspections by Mr. Darka, the owner of Buffalo Management, before the vehicle was released. It was released because it was 10 years old. And they didn't find any defect with the doors. The doors are open and used normally. So I guess I do not agree that there's proof of a defect initially. And then there's a suggestion there's no inspections. Of course, there's a New York State inspection that's talked about. There's a City of Buffalo annual inspection that's talked about. And the inspections that my client testified to were, well, we change the oil every 6,000 miles. When we do that, the mechanic goes over the car. The question is does there have to be a more checklist, more, I don't know that there's any proof that it would make any difference. And it's just, go ahead.
Separate and apart from the door handle for just a second. Do you believe that it's necessary that there be legislation requiring partitions and cameras for an owner of a cab to be negligent by not providing it? Or could you envision a scenario where so many cab drivers are getting robbed at gunpoint that at some point, gee, it's negligence just to not have that partition up at this point?
Yeah, I don't know. The court below addressed this. They said there were no regulations. I don't know whether an argument could be made that there should be. The court also points out, though, that the partitions are not bulletproof, wouldn't prevent this from happening. And the cameras, of course, may record, but they wouldn't necessarily prevent it.
But there's some testimony in the record from OSHA that it's shown to be effective. Shown to be effective at curbing robberies, having cameras, having partitions up, because it just makes it more difficult.
Well, the court found no duty. Our position, there is no duty without any regulations. Obviously, the argument can be made, and it would be up to this court to decide whether.
How many cab drivers have to get robbed at gunpoint before there's a duty?
That's a question that's beyond me. I'm not the legislature.
Fair enough.
So, there is a practice and procedure which Judge Montour brought up of the cab drivers. They're going there every day. They're independent contractors. They've got a responsibility to look over the cab, make sure it's right, and then operate it. And if they find something wrong, to tell somebody that something's wrong with it. There's, I think I read in Napa, there's 30,000 parts on an automobile. So to say that you're responsible to inspect an owner that is leased it to Liberty, to say that somehow they're responsible to check every part of a car every day is an unreasonable level of responsibility. Negligence is based on what a reasonably prudent person would do.
I think we understand that.
I understand that. Thank you, Your Honor. And then the court brought up the Santiago case, which, of course, was a jammed door. It's about as close as you're going to get. You got a jammed door, the person can't get in, they get shot. They say that it's a superseding cause, that it cuts the chain of causation. That I think is the main issue here, and I think that is the law. And in this case, the shooting, the claim by the expert is that the shooting is because of the door. He could have been agitated because he's in the midst of an armed robbery. He could have been agitated because the man only had $5. He could just be a sociopath. The idea that this shooting even came from that door, there's not much to support that. Yeah, he was aggravated, but is that the reason there's a shooting? He may be shooting him to try to get rid of a witness. I mean, an innumerable number of reasons why the shooting. So there's no, the causal chain is broken. I think there's the court, Judge Furlong wrote a very thorough decision addressing that issue. That's the position of my clients, and thank you, Your Honors.
Thank you. Number 90, James Scheider versus Stacia Scheider.
Good morning, Your Honors. May it please the Court, Stacia Scheider representing myself in an appeal asking that the court vacate a decision and order that was issued by the judge in my divorce case, making me responsible for half of the guardian ad litem fees. The issue of who would be responsible for the guardian ad litem fees was never raised until the final minutes of the divorce settlement, and it was a divorce that took nearly 5 years to get through. It was an issue that made me responsible for half of more than $10,000 in the guardian fees. The action for divorce was filed on June 5th of 2017, and Attorney Baker, the guardian, wasn't appointed until January of 2019, which was a full year and a half after the start of the divorce. I was told the guardian would help facilitate the issues of the divorce. However, the fact was the guardian teamed up with the plaintiff's attorneys and did not help to facilitate in any way, but created obstacles. We were close to a settlement in the early part of the divorce in early 2019 when the guardian interjected into the settlement the concept, I own a real estate business, a small business, 2 part-time agents, but he interjected that that business had a large value. He then asked my husband's attorney at the time to act as the expert witness to place the value on my business, and the judge never refuted that. I was then forced to hire an independent firm to step in to place a value on the business. And I've been in real estate for 44 years. Yes, in my heyday when I had a dozen agents, but I'm at the point of retirement. There's 2 part-time agents. That independent firm was costly for me to bring in, and had I known that I was going to be asked to pay for half of these guardian fees, I would have asked for proof in the beginning. We did make a motion for proof that Mr. Sheeter, my ex-husband, needed a guardian because it was a 1.5 years in, and we were denied that motion. We made a motion asking for proof. The guardian eventually, late in the divorce, dropped the issue of the high value on my business, but by that point, he's already billed for all of these hours and years that were wasted. All I can say is I felt abused by the system. The settlement we eventually agreed upon 5 years in was the same settlement that we were agreeing upon the first year in the divorce. And my first point in the brief was that did the court err in upholding the award of attorney fees without allowing me to submit opposition? At the end of the divorce, the judge stated that Attorney Baker, the guardian, would have 2 weeks to present his bills to the court and to myself, and I would have 2 weeks to refute those bills or to give my opinion. And I was denied that due process because the documents served by the guardian ad litem were never received by my attorney or myself. So we received 2.5 months after the divorce a notice saying that I was responsible for 50% of the fees. My attorney reached out to the court and stated we never received any bills from Attorney Baker, the guardian, and we asked for time to prove that we didn't receive it. We poured over the emails. We contacted an IT company. They said that we should ask for a subpoena through Google to prove that we didn't receive it, and we made a motion asking for that, and my attorney requested that, and it was denied by the court. The following morning, we were told that it was going to be placed on file, even though we asked to have the order set aside. It's just been a very long process, and I had 3 points in the argument, the first one being the fact that I was not allowed the right to subpoena Google or to prove that I was not served with the proper paperwork. The second point in the brief was, did the court abuse its discretion by allowing Attorney Baker to act as guardian ad litem and award those fees without an order appointing him? Attorney Baker failed to have himself formally appointed when he was placed as guardian ad litem in 2019. He took on the role, but my attorney uncovered in April of 2021, 2.5 years later, that Attorney Baker had never had himself formally appointed.
We'll look at that.
Thank you. Point 3 in the argument was, did Attorney Peter Baker err in failing to have himself legally appointed by the court as the guardian ad litem when he agreed to take on the role and have his responsibilities and duties defined? Attorney Baker did not secure the court order. He did not define his responsibilities. Throughout the case, there was a motion made, as I said, asking for proof that Mr. Sheeter needed a guardian. He had 2 sisters who were his powers of attorney. He had 2 attorneys. And that motion was denied. We were never allowed proof. The guardian unilaterally joined forces with the attorneys in the case, working against my interest. and never brought up the fact that I could be responsible until the final minutes of a 5-year-long divorce.
We'll look at that very carefully.
Thank you. Do you have any questions for me? Nothing. Okay.
Thank you.
Thank you very much for your time.